after failing to appear, and we don't have any way to remedy that going forward. And if the Ninth Circuit's rule stands...
I appreciate the force of the point, Mr. McLeod, but there are so many people because the government was out of compliance with the statute for so long. And so at a certain point, it's just, you can't sort of ask us to read the statute against what the statute says, because we've created a world in which kind of we've long since forgotten what the statute says.
So respectfully, Justice Kagan, that's not what we're asking you. We're asking you to apply the statute as it's written. And that is a statute that permits in absentia removal when a non-citizen received notice under either paragraph 1 or paragraph 2. And all the non-citizens here got the paragraph 2 notice. They haven't contested that they received notice of when and where to show up.
That's what most fundamentally I find a little bit discomforting about your argument, this idea that there are two forms of notice. Take your pick. If one is good, who cares about the other? I mean, it seems to me that if you read this statute fairly, it's quite clearly, and this is what we said in our two prior cases, you know, A1 is the notice. That's the notice. And what A2, it tells you what you have to put in it, all the things that you have to do. Here are the charges, here's your right to counsel, and here's when you're supposed to show up. And what A2 was about is Congress understood that there were going to be times when you were told to show up on March 15th, and then it turned out that March 15th was impracticable or impossible for any of a number of reasons. And it was a mechanism to say, okay, we don't mean March 15th, instead show up on August 15th. But that's what the function of A2 is. It's not some completely distinct form of notice that you can say, hey, look, we did that one.
I just disagree, Your Honor. I think that the A2 notice serves a distinct purpose, and that purpose is to provide the non-citizen with the information they need to know in order to decide whether they want to attend the removal hearing or not. And
doesn't it also serve the purpose of giving the government the right to remove them in absentia? I mean, the thing that's a little concerning to me about the way the government has constructed its argument here is the suggestion that we ignore 1229A5A, which requires the government to give the person notice as a prerequisite for the government's ability to take advantage of the procedure of removing them without a hearing. So I guess I'm a little concerned that what you're suggesting is that we should presume that the removal is proper, the removal order is proper, even if the notice was defective. And now it's on the non-citizen to say something, or it shifts to his burden to prove, that he should not be removed under those circumstances.
A couple of responses, Your Honor. First, we are not asking you to read out of the statute the paragraph 2 notice or to ignore the paragraph 1 notice. We're saying both of those notices are relevant for purposes of in absentia removal, and we bear the burden as the government of proving that the non-citizen got notice. But that notice can be in the form of the paragraph 1 notice or the paragraph 2.
But how do you square that with the prior cases? I don't understand your distinction. Maybe I would understand it if we hadn't already looked at this same circumstance to determine whether a notice is defective and what is the consequence of that. So in Pereira, we said if it doesn't have the time or place, the notice to appear, then it's defective. And as I read Chavez, we say the government can't cure that deficiency for the purpose of the stop time rule by providing a paragraph 2 notice. So the government, I think, has to say there's something different about this scenario, the removal scenario in absentia, than the stop time rule scenario.
And there are two significant differences.
Okay.
One is textual and one is based on legislative history and drafting. So the textual difference is that for purposes of the stop time rule, the only notice that is relevant is the notice to appear. That is the only notice that is referred to in that provision.
Why do you say that? I'm sorry.
Because when you look at the text of the stop time rule, it says it is triggered based on the service of a notice to appear. There is no reference to the notice of hearing.
But it says